Have you ever wondered how complex societies could maintain peace and order, even when disputes arise, without relying on a centralized government or state monopoly on justice? Imagine a system where resolution stems from mutual agreement and reputation, rather than coercive power. Dispute resolution organizations, or DROs, primarily function as voluntary service providers that offer impartial adjudication, mediation, and arbitration to resolve disagreements between individuals or groups. Their core purpose is to provide a non-coercive means for parties to settle their conflicts, ensuring contracts are upheld and property rights are respected within a framework of voluntary law. The fundamental mechanism enabling DROs to operate effectively lies in the principle of voluntary participation and the power of reputation and contract law. Parties freely choose to subscribe to a DRO, agreeing beforehand to abide by its rules and judgments. This voluntary contract forms the basis of the DRO's authority, rather than any claim to territorial sovereignty. Furthermore, a DRO's long-term success is directly tied to its reputation for fairness, efficiency, and consistent application of justice. Should a DRO issue biased or incompetent rulings, it would quickly lose clients to competing organizations, which is a powerful market incentive for impartiality and high standards. This competitive environment fosters what is known as polycentric law, where multiple legal systems coexist and individuals choose which system best serves their interests. For individuals or businesses considering DRO services, the process typically involves selecting an organization whose contractual terms align with their values and needs. This might mean joining a DRO that specializes in commercial disputes or one focused on personal property conflicts. Once a dispute arises, both parties submit to the DRO's chosen method, whether it is mediation to find a compromise or arbitration where an impartial third party makes a binding decision based on pre-agreed rules. Enforcement of these decisions relies heavily on the reputation of the involved parties and the DRO itself. A party that consistently defaults on DRO judgments would find it increasingly difficult to engage in future voluntary transactions, as their trustworthiness would be severely damaged. This approach allows for incredible flexibility and innovation in legal services, departing from the rigid, one-size-fits-all model of state-imposed law. Historically, private law societies and merchant courts have operated in similar ways, demonstrating that effective non-state dispute resolution is not merely a theoretical concept but has practical historical precedence. They often develop specialized expertise in particular areas of law, offering more tailored and efficient solutions than a general court system. The market for dispute resolution services encourages DROs to offer diverse contractual options, allowing individuals to select justice systems that best reflected their moral and ethical standards. Ultimately, DROs exemplify how order can spontaneously emerge from voluntary cooperation and the pursuit of mutual benefit, rather than through centralized authority. By offering transparent, competitive, and reputation-driven services, these organizations provide a robust framework for resolving conflicts, protecting property, and upholding contracts, thereby promoting a peaceful and prosperous society grounded in individual liberty and consent.